First of all, my name is Christopher Denton. I represent a number of landowners along the pipeline, in fact, along several different routes. Let me second the remarks of Jim Wharton. We very much appreciate you holding a local meeting. It's very important. None of us would be able to go to Washington. And it does give us an opportunity to inform you of the unique local circumstances that we may have in New York. Also, let me second the remarks of Mr. Wharton concerning the very narrow window when this period closes, including the fact that maps were not delivered to the towns or to many of the landowners, so they were unable to come prepared. Like an appellate division, people like to be a hot bench, they want to be there and ready, and they couldn't prepare for this period. So we think that the October 9th, which is really only 7 business days, really is too short a period for the shows. We would recommend at least November up to December 1st would be appropriate. And as Mr. Wharton said, the things which can run with this at the same time concurrently can continue to go ahead. My concern, although I do represent landowners and I do oil and gas work, I also represent clients in bankruptcy. I've been a real estate attorney for over 35 years and have been a title agent for over 30. I am steeped in real property law and bankruptcy. And one of the continuing problems that has occurred is bankruptcy and the fact that the companies are not condemning the fee interest, but an easement. Now, an easement can be returned at any time, can be surrendered as a matter of law. Now, whether you allow that is an interesting note, but in bankruptcy, if the pipeline company should file bankruptcy, the bankruptcy trustee who takes possession of the assets of the pipeline company is not going to run a defunct pipeline. They're either going to sell it, if there's no market for it, they're going to abandon it in place. It's a 30-inch pipeline. A 30-inch pipeline abandoned in place will begin to rust immediately. Once you take all the cathode tubes off it, all the things that prevent rust, the maintenance stops. And a 30-inch pipeline, once it rusts, once there are holes in it, groundwater, of which there is a lot in this area, will run in and it will become an underground conduit. It either will put water to an area that it shouldn't go to, or it will fill up the pipeline and accelerate the rusting course process. Eventually, the roof of that pipeline will collapse. When that happens, we'll have a 30-inch subsidence in the soil. Now we'll have a gully, whether it's in the middle of a farm field, whether it's on traversing a slope, or directly down a slope. And a 30-inch gully will produce an extraordinary amount of accumulated runoff very quickly. And the farmer, the landowner who has that, will have an extraordinary environmental erosion problem, as well as a silting problem for any creeks that might run into. Now, the current process does not address what happens if the company goes bankrupt, or simply says, we're tired of this project. Or sustainable energy actually takes over the world and they don't need the pipeline. Something like that happens. The landowner will be stuck with this issue and without compensation. The current methodology for eminent domain on an easement is that the landowner is paid eminent domain in New York State on either across the fence methodology or paired sales, which basically means what was the value of the land before the easement went in and what is the value after. Well, for farmland, which may run $1,000 an acre, and for which afterwards it's perfectly usable as farmland, there may be almost no difference. So the company has taken economic benefit without effectively paying. And in fact, we have lost several cases where New York State has held 40-foot wide easement, 1,000 feet long, is less than an acre. And if the property is worth $1,000 an acre, $900 for this easement. Now just add that up right along the 121 miles, And this is practically grand theft. Not only that, it's inconsistent with the way the industry actually negotiates these. I've negotiated pipeline easements for over 12 years. Every time we've had a gathering line for which there is no right of eminent domain, the company has been very reasonable. We get a very strong easement protecting the individual landowner, usually about 6 or 8 pages long, including indemnity agreements, insurance, restoration, attorney's fees if we have to sue without them getting theirs, baseline testing, water, soil, air, before, during, and after, compensation package that in some cases, 1 9-mile pipeline, for which Mr. Gordon was involved, we actually limited the easement to 40 years. 20-year easement with a 20-year renewal. Now, this has an environmental impact because if you make it perpetual, then there is no idea or no contemplated return of this property to its former state. And if you make it limited, as BLM, that's the Bureau of Land Management, and the Indian tribes around west, where there is no sovereign immunity, there's sovereign immunity and there is no eminent domain, they're basically 10-year rental agreements with renewals with a renegotiation based on appraisals for the next 10 years. So what I'm getting at is that the fact that the pipeline can be abandoned in place as a matter of law by bankruptcy is an extremely important environmental issue which needs to be addressed in the environmental impact statement. If it is not, then the landowner will be left at some time in the future with either having basically a pipe dump site for which he or she is responsible, or if they are compensated, they should be compensated for the current value of removal of that pipeline and the restoration of the land under current rates, not future rate, but current rate. Now, the landowner could then bank that, so it would be there at the time when they have to use it to take it out. Having a bond isn't going to last for 50 years. It's not going to last for 40 years. And bonds can be gotten rid of in a Chapter 11 proceeding, that I'm aware of. So putting in elements that purport to insure against this happening doesn't help. This board, the commissioners, have in a recent storage facility, gas storage facility certificate in Steuben County, required the company to reimburse the landowners for the gas trapped in a Marcellus formation, which they could not drill because it was the cap rock. It was in the order requiring them to pay them the compensation for that loss of gas. All we ask is that the landowners be paid for the cost of removal of that pipe up front and the cost of restoration. Thank you very much.